Hello everybody and welcome back. My name is Chase Keebler and I am the managing attorney and founder here at Keebler Law Group. Today I'm here to talk a little bit about class actions both in the federal sense and in South Carolina in particular. Now, a class action is, you've probably heard of it before, but it's where a group of collective members who have suffered a similar injury sue as a collective group or a class against a group, either one defendant or a group of defendants. It really depends on kind of what type of class it is. Now, under the federal rules, there are a number of requirements to be met in order to certify a class. Now, what happens is you will file a case as a class action. You may take part in a little bit of minor discovery, and then you will get into what's called class certification stage. Now, to certify a class in federal court, there are 4 requirements. And that first requirement is that the class must be so numerous that it's not practical to handle all these claims on an individual basis. This is subjective. It doesn't have to be, there's not a hard and set number. It could be 30 individuals or it could be hundreds of individuals. Really, it's on a case-by-case situation. The second requirement is that there must be common questions of law for all members of the class. And this makes sense. We want to adjudicate these issues fairly for the defendant as well. So the defendant must not have particularized defenses against each individual plaintiff, but all these defenses against the class as a whole. And that kind of is the same for the plaintiff's claims. They have to kind of all be categorized as the same type of claim as opposed to individual or particularized claims. Number 3, there must be one or more members of the group that are representative of all the members. So we must have a class representative that will advocate on behalf of the group, and there are certain kind of requirements and criteria that class member must have. But really what it comes down to is will that person be a good representative for other injured class members in the class group? And finally, in the same kind of vein, that appointed class representative must adequately represent all the interests of others. Again, it kind of goes to ensuring justice is met for the entire group as a whole and not just one individual pursuing an individual claim. Now, class actions are a fairly complex civil mechanism that's created by the rules. There are certainly benefits and disadvantages to filing a class action. An experienced class action attorney will be able to kind of analyze your factual circumstance and see whether or not you may have a class action if your injury involves a broad group of individuals with very similar claims, very similar damages, very similar theories. That's kind of where it's appropriate to have a class action. Now, in federal court, the total amount in controversy must be greater than $5 million. It sounds like a lot of money, but really it's not very hard to hit for these class actions. If we have a nationwide supplier of, say, something you see in a grocery market that was tainted, that could easily, the particular product might only be $5, but whenever you look at it as a nationwide as a whole, you can easily see how that can surpass the $5 million threshold. Again, this all depends on the type of injury incurred and the type of class alleged. South Carolina has its own Rule 23 class action requirements, and they are substantially similar to the federal requirements. However, where they kind of differ a little bit is the amount in controversy rule. In South Carolina, the amount in controversy, each individual class member must have suffered at least $100 worth of damages. Again, this is not a very difficult bar to hit, but it's kind of even further narrowing the ability to use this civil tool in the state of South Carolina. Some common types of class actions that we see are class actions for product liability. Those include, when if a brake manufacturer messed up manufacturing a whole lot of brakes, those types of recalls. Other types of class actions you see are antitrust litigation class actions, where you have a group of an impacted market who had suffered from a price fixing cartel. You have class actions for environmental concerns and non-environmental cases whenever there's a spill or a leak. Similarly situated landowners are damaged in a very similar way. The claims are very analogous. And sometimes you see mass torts such as a plane accident being brought in a class action format. Again, liability is very similar. Damages might be a little bit different of a conversation, but looping all plaintiffs in one and having an adequate representative really might be a valuable tool for other class members. If you think that you might have been impacted, or if you think that you have a class action that you might be interested in pursuing, or if you have seen a class action that you might be a member of, please do not hesitate to reach out to me. The quickest way to get in touch with us is to fill out our general intake form. That comes right into our system, puts you as a contact, and we will reach out to you within 24 hours. Typically, we do it much quicker. As always, you can give our office a call or send us an email. I appreciate you taking the time to watch this video. And again, if you have any questions, do not hesitate to reach out to me. All right. Thanks, everybody. Bye.